Committee on Digital Assets.
Thank you very much, Mr. Chairman. Appreciate all of you being here today. As chairman of the committee, on the subcommittee on digital assets, I take great interest to this and appreciate you, Mr. Chairman, for waving me on to the committee today on what has been an incredibly important conversation. My colleague across the aisle, in his closing remarks for the minority, referenced that Choke Point 2.0 might be a made-up statement. But I feel like that is as if you open the door of your home, the sidewalk and driveway is wet, and you conclude, aha, but I didn't see the rain. It's pretty obvious what's going on when you actually look behind the hood and use common sense, just like you would if you open your door and you look out and your driveway is wet. Common sense tells you that it rained. If we look at what played out in the Biden administration through the regulators and what played out through their pause letters, which we've discussed today, through informal or offline means, it was pressure of financial institutions to debank digital asset firms and to make sure that those individuals understood that that pressure was there across the ecosystem. And I think that's what we really see today at today's committee hearing. And it's the importance of not allowing, as we discovered in Choke Point 1.0 with our Second Amendment rights, not allowing the regulators to drive forward a political agenda through their authority as regulators to correctly assess risk across the system, but not to put their finger on the scale as it results in their individual view of any given industry that the bank or financial system should be lending into. So I think with that is kind of a stage setting. What I want to do is dig in briefly, if I can. I'll start with you, Mr. Campa, and I'll move along. I think one of the important parts here to discuss is kind of how bank examiners define traditional risk and how it's different from reputational risk. Succinctly, can you give me the difference between those? Because I want to build on that.
Yes, reputational risk is essentially we believe a bank is doing something that could damage its reputation in some ways that would cause customers to disfavor it versus forms of business risk that are more objective, like you're lending to very risky people.
And so would reputational risk, could that be used as a shield for regulators to inject political objectives into the banking system?
It certainly could be, yes.
And do you think that was the case as it relates to crypto investments?
Well, I mean, there's a great example of that. Paxos ran BUSD in New York. They've been regulating stablecoins since 2018, and thanks to regulatory pressure, that had to be shut down. Like, I have the privilege of having built one of two stablecoins that was above 10 billion and went back to zero. We disrupted no markets, returned every penny. There was no danger to everybody, and shutting it down benefited Tether.
Let me jump to you, Mr. Graywell, if I can, to build on this. In your experience, how do regulators and banks think about reputational risk, and to what extent does the political bias or policy bias of the regulators, how are they leveraging those two risks to drive their agenda?
Well, reputation in banking matters, Congressman. There's no question about it, but it too often is used as a catch-all or an excuse for other considerations that have no basis in law or, frankly, no basis in fairness. There's no question that additional guidance from this Congress would be extraordinarily helpful in cabining and restricting the use of reputational risk to simply deem unacceptable all sorts of industries or individuals who happen to be out of political favor.
Yeah, and I think broadly speaking, as we wrap up today's hearing, and thank you, Mr. Chairman, for scheduling it, this is a broader point that politics don't belong in our banking laws. And what we want is the regulators on their task to analyze actual risk in the system rather than putting their finger on the scale to drive forward their own partisan, political, or social agenda. And so having today's hearing on Choke Point 2.0 in a recognition that this really was occurring by the regulators inside the Biden administration, I think is important. I think it's a bit naive or attempting to discredit the facts to say that that it's not occurring. And again, I go back to my analogy. If you open the door of your home and the pavement's wet and your driveway is wet, it rained. And as we look back as to what happened inside our financial system under the Biden administration, we could have a debate of whether or not you'd feel like you need more evidence, but I think the evidence is pretty clear. It rained. And we need to stop this, and we have a real opportunity. One final point, it was referenced that legislation didn't get done in the previous Congress under the Biden administration. The good news is we have Republican unified control, and I think we got a great opportunity for Congress to act. Look forward to working with everybody. Mr. Chairman, I yield back.
Gentleman yields. Before we adjourn, I'm going to take a point of personal privilege and yield to the ranking member.
Thank you again for your kindness, Mr. Chairman. Mr. Chairman, sadly today